The information contained herein is provided for entertainment and informational purposes only and should not be construed as legal advice on any subject matter. The content of this show contains general information and may not reflect current legal developments, verdicts, or settlements. Any information contained in this show is not intended to be a substitute for legal counsel.
Hello, everybody, and welcome to another episode with Grant Gisondo, the Family Man. I'm the owner of the law offices of Grant Gisondo, PA, a full-service family law firm located in Palm Beach Gardens, Florida. Call us today for a free in-person consultation regarding any family law case, 561-530-4568, or online at sunshinedivorce.com. We will fight for you each step of the way. Again, that number is 561-530-4568. Thanks a lot for tuning in. We are talking about child support and child custody, and I am very, very honored to introduce our special guest today, Magistrate Thomas Baker. Please say hello.
Hi, Grant. Thanks for having me on.
Truly an honor to have you here. Today, folks, we have a little bit of a special episode in store for you. Magistrate Baker is a magistrate at the West Palm Beach Courthouse that's going to be giving us some judicial insights to our conversation about child support, time sharing with your children, and pretty much everything you need to know about going through a custody case here in South Florida. Just as a brief overview, Magistrate Baker, and if it's okay if I call you Magistrate?
That's fine, thanks.
Great. Okay, Magistrate, why don't you tell us a little bit about you, a little bit about your history? How'd you get started?
Well, I grew up here in Palm Beach County and went to the University of Florida for my undergraduate degree, but went off to Houston, Texas, where I went to law school, but I missed Florida and wanted to come back, so I did, and worked for a big firm for a couple of years and really learned a lot about participating in trials and how to conduct myself in a courtroom. And that gave me the confidence to go and open up my own office. So I had my own family law practice in Jupiter for about 20 years before an opportunity came up to apply to be a magistrate. So I decided to put my name in, and myself and another magistrate were appointed to fill a couple of new seats that had opened up, and it's something that I've really enjoyed for the last 10 years.
Great. Very, very cool. A lot of folks don't know what a magistrate is, how a judge and a magistrate are different. Would you feel comfortable giving us a little bit of an insight about how all that works?
I'll try to make it, or try to help make it be sensible. It's the difference primarily is that judges are constitutionally elected officers. Even though judges might initially be appointed by the governor, at some point they have to come up for election, and so they serve 6-year terms and have to run every election cycle, but they typically a sitting judge doesn't draw any opposition. Magistrates, on the other hand, are appointed by the chief judge in the circuit where they're located. And so it's basically a magistrate is the employee of the state and serves at the discretion of the judges in that particular circuit. So one of the differences as far as the work we do is that judges get rotated around into different types of law. A judge might serve in criminal division for a couple of years and then go to civil division for a couple of years. And usually all the judges at some point have to come into family division where they'll serve for a couple of years. But then they'll move on. The magistrates, all we do is family law, 100%. Or there is a juvenile division and one of the magistrates serves in there. But even the magistrates rotate around from Department of Revenue Child Support Enforcement to family division, which can also encompass timesharing, and then this juvenile division as well.
Very cool. Okay, so from a layperson's perspective, you're essentially you work for the state, and you have some of the same powers as a judge, that you can preside over certain type of family law cases. And I'm assuming that this was enacted so the judges didn't have so much work on their plate that some could be divvied out to magistrates?
Right. That's the whole idea, was to take the workload off of the judges. It's just overwhelming, the number of cases that come in. So the legislature funded and then the court system created these positions of magistrates and hearing officers to help reduce the caseload of the judges. And so primarily magistrates here in Palm Beach County hear what we call post-judgment cases. After a paternity action has been finalized or a divorce action has been finalized and there's a final judgment entered, things that occur after that are initially referred to the magistrates. So anything that might have to do with enforcing a final judgment or modifying a final judgment will go to the magistrate. Now, there is a possibility that someone may opt out from having the magistrate hear the case if it is a non-child support issue. So things like timesharing or alimony or attorney's fees, either the person themselves or if they have an attorney can file an objection to the referral to the magistrate. And then those cases go back to the judge. But all child support matters and child support related matters, such as child support or medical expenses, non-covered medical expenses, child care, aftercare, things like that, they stay with the magistrate, even if someone doesn't want the magistrate to hear that particular motion or petition that might be affected. So that's the main thing for the magistrates, is to hear the post-judgment matters.
Okay, so what I'm hearing basically is that if a final judgment has been entered, basically the judge is going to refer the case to you after a final judgment for a modification or enforcement of child support, something along those lines. But if at that point the people don't want to be in front of a magistrate, they can object, and then it's going to be referred back to the judge to hear the case. But there's certain things now that magistrates have exclusive jurisdiction over. Is that correct?
That's correct.
Okay, so basically that even if you don't want to be in front of a magistrate, for whatever reason that is, you're with the magistrate for things like child support. You have exclusive jurisdiction over child support matters, right?
Correct.
And then as well as enforcement of medical expenses, attorney's fees, things like that post-judgment?
Well, they could still opt out of the attorney's fees. It's interesting and somewhat complicated, where maybe there's a motion for contempt for child support, but there's also a request for attorney's fees. And a party could object to the magistrate hearing the attorney's fees portion. It's not a very good system as far as judicial economy goes, because if that happens, the magistrate's still going to hear the child support issue, but then everybody's going to have to come back for another hearing in front of the judge concerning attorney's fees.
Right.
So it's interesting from the point of view of an attorney and their client as to whether or not they should object, whether they think a particular magistrate maybe is not favorable to an issue that they have, or that the judge just maybe is very familiar with the whole case. And you just have to sit down and have those discussions with each other as to what the strategy should be on whether the magistrate should hear all or part of the case.
And folks, that's a great point. And one of the things there is why it's so important that you hire an experienced family law attorney in these matters. What he's saying is that basically if you have a portion of your trial in front of the magistrate, you still might have a portion of your trial in front of the judge. And then you're paying for basically 2 contested hearings or 2 trials or evidentiary hearings, which can get quite expensive. So I've always been of the opinion that the way that I practice law, especially with my clients, is that we need to get you to a certain point as cost efficiently as possible. And sometimes having 2 trials or two issues, one in front of the magistrate and one in front of the judge, all it really does is up the fees. So I always try to, if the magistrate is going to hear the child support, let's have the attorney's fees in that same hearing. If the judge is going to hear an issue, let's keep all the issues in front of the judge. That way you're not paying for the same work kind of twice for 2 different issues. I think it just moves things along a little bit quicker. If you're just tuning in, folks, this is Grant Gisondo, the Family Man. I'm joined with the Honorable Magistrate Thomas Baker today, and we're talking all about child support. If you have any questions about any of the stuff that we're talking about today, or there's a topic you'd like for us to cover in the future, feel free to give me a call, 561-530-4568, or you're welcome to drop me an email, grant@sunshinedivorce.com. Again, that's grant@sunshinedivorce.com. Now, if you're just tuning in and you're a regular listener to our show, last week we were talking about some of the factors that go into determining how much time a a parent's going to have with the child. We got through about 4 before we had to get to some frequently asked questions, but we're going to get through some more today. But before I do that, I want to give you guys a little recap in case you missed the beginning of last week's show. So the beginning of last week's show, we went through a couple factors. Some of those factors, now Magistrate Baker, if you want to tune in and talk about any of these factors, let me know. I'm happy to take a break and we can do that. So one of the major factors that we're looking at under the statute is the demonstrated capacity and disposition of each parent to encourage a close and continuing parent-child relationship, to honor a time-sharing schedule, and be reasonable when changes are required. Now, I litigate a lot of these cases, and one of the biggest topics under this factor is the encouragement of a close, continuing parent relationship. It's kind of a hot topic right now. What this basically means, or what I've always litigated that it means, is that both parents need to do everything they can to give the other parent fair access to the child, and also don't badmouth the other parent. Remember, your children love each of you, whether it's a mother or father, and you don't want to do anything that would hurt the other parent's, the child's feelings about the other parent. That can work against you in this situation. Magistrate, would you kind of agree that both parents kind of have an obligation to get along for the child and not kind of alienate the other parent in front of the child?
Absolutely. One of the things that I see a lot of is one parent undermining extracurricular activities. And it could be just school functions, or it could be Little League Baseball, just as an example. And the way the law works is that when the child is with a particular parent, that parent gets to decide what the child's doing. But if the child is involved in ballet or baseball and it's something they really enjoy, it's unfortunate when I'll see that the parent wants to put their own interests ahead of what the child might want to do, or what's in, I hate to say the best interest of the child is to participate in extracurricular activities, but it's part of growing up. And it's tough when I see that, parents are not working together for, what would make the child's life the most manageable, or the thing that they would enjoy and enjoy their childhood, as opposed to having the parents fight about every little thing.
Right. And that's our major topic, folks. We spoke about that for a long time on the last show, the best interest of the child as opposed to the parent's best interest. You really need to be making decisions on what's going to be best for your child. If your child has a desire to play baseball, enroll them in the baseball, figure out how you're going to get them to practices, how you're going to get them to games. That's a great topic. I agree. Moving along a little bit, one of the things that the court is going to be considering is parental responsibilities delegated to third parties, babysitters, daycares, things like that. We don't need to talk too much about that. Demonstrated capacity and disposition of each parent to act upon the needs of the child as opposed to the needs of the parent. Again, best interest of the child, not the best interest of the parent. Make sure that you're meeting all the needs of the child and you're not being basically selfish is the way that I would take this to mean. The next one, and this is a factor that I think, and maybe you're of course, Magistrate Baker, you're free to agree or disagree with me on this one, but the length of time the child has lived in a stable, satisfactory environment. I've always made sure I put on evidence about this. I think the courts, of course, in my opinion, really want to see the child, living a consistent routine. They don't want to see a lot of moves. They don't want to see different schools. They really want consistency in a child's life. Is that something you'd agree with or you'd disagree with?
No, that's a big one for me, Grant. When I have a situation where a child has been attending the same school, say elementary school, for example, for 4 years, and then one of the parents wants to uproot the child, and the child's been living in the same neighborhood and has the same friends and the same interests, that's where I want to keep them. I want to keep that stability, unless there's some other problem
right, of course,
that might be going on. But ideally, yeah, we want to just make things normal for the child. We don't want to see a lot of changes.
Right. Consistency, stability, basically stability. is what it's coming down to. Okay, folks, if you're just tuning in, this is Grant Gisondo, the Family Man. I'm the owner of the law offices of Grant Gisondo, PA. We are a full-service family law firm located in Palm Beach Gardens, Florida. Feel free to call us today for a free in-person consultation regarding any family law case, 561-530-4568, or online at Sunshine Divorce. Today we are with Magistrate Thomas Baker, one of the magistrates at the West Palm Beach Courthouse, talking all about timesharing as well as child support. We're going to take a little break and we'll be right back talking about some of these factors. See you in just a minute.
Non-attorney spokesperson.
Without the proper training, diffusing a highly volatile bomb is not something you want to try by yourself. When a marriage is about to explode, the same wisdom applies. Hire a professional or pay the consequence.
Headed for divorce? Diffuse the matter with the guidance of the law offices of Grant Gisondo. Online at sunshinedivorce.com. That's sunshinedivorce.com. Main office in Palm Beach Gardens.
Welcome back, everybody. This is Grant Gisondo, the Family Man, the owner of the law offices of Grant Gisondo, PA, a full-service family law firm located in Palm Beach Gardens. You're welcome to call us today for a free in-person consultation regarding any family law case, 561-530-4568. We will fight for you each step of the way. 561-530-4568. I'm joined today by Magistrate Thomas Baker, one of the magistrates over there in West Palm Beach Courthouse, talking all about time-sharing factors as well as child support. Been going through these factors, getting some amazing insights from a judicial perspective today. The next factor that we're going to talk about is moral fitness as a parent. Now, this is probably one of the most commonly litigated issues or factors that come up in this incredibly long statute here today. Magistrate Baker, I'm going to ask you, moral fitness as a parent. Does this mean if you cheat on your spouse, you're not morally fit, or is that moral fitness as a husband or wife? Are we talking about moral fitness as in breaking the law? What exactly, from a judicial perspective, how are you looking at moral fitness?
Well, if I get off track here, kind of circle me back around to the original question.
Okay.
One of the things that I'm sure you've mentioned when you started this topic, however many weeks ago that might have been, is there's 20 different factors just in the statute. And sometimes parties will appear before me and they'll get locked into one little thing, like some big fight at a picnic or something. And while that might be a piece of the puzzle, that's all it is. It's not worth spending 30 minutes of court time on when there's 20 statutory factors and then 1,000 other factors that the court is looking at when it's trying to make a decision. And it's a little overwhelming when you do look at all the different factors and try to think of all the different things that are important.
So I think you're saying this isn't a super factor. There are no super factors, that this is just mainly, like you said, one piece of the puzzle. So don't focus on just one thing, look at the big picture.
Correct. It's definitely a big picture thing. Now, certainly judges and magistrates are human, and everybody's going to have their own little idiosyncrasy as to what is more important to them than maybe the next person or next judicial officer. But it's a big picture thing. And so something like moral fitness is tough to define, and it's not just because maybe you cheated on your spouse that's going to win the case. It's a matter of looking at the totality of everything. But certainly there are things that pop up, and more recently I see more and more litigants bringing into court printouts of the other person's Facebook page, for example, or whatever other kinds of social media is out there. So
I do it all the time. I'm guilty. I got to tell you, I'm printing those pages out and I'm putting them in front of the judges.
But I mean, that's very telling. I mean, it's one thing to have somebody come in and say, well, they do drugs, or they say bad words in front of the kids. But all of a sudden, when you have a Facebook post that where the person is sitting there wearing a T-shirt that badmouths the other parent, says mommy is a B word or whatever, and the kid's right there, where they're sitting there smoking marijuana, or they've got their guns laid out on the bed, for display. eventually you kind of wins you over. Like, maybe this person does have some questionable, background, or maybe they're not the person that should be making decisions that are going to affect these children.
And folks, what he's saying is so true. I cannot even tell you how many photos I've seen from clients that has 2 guns, a pile of marijuana, and a bunch of paraphernalia devices next to it. I don't know if there's some type of a market. Like, why would you take pictures of guns and drugs and put them on Facebook? I don't see it, but it happens every day. It's so true. If you guys are doing something like that, please stop, because it's just stupid. So I know none of my listeners would ever do anything so foolish, but if you're listening to a friend's radio and you've done this, please don't do it. But okay, back with Magistrate Baker talking about moral fitness. I'm gonna let you continue. I won't interrupt.
Well, there's just other more parenting decisions too. Last year I had a case where a minor was allowed to get a tattoo by one parent, but they didn't get the permission. And I hate to use the word permission, but you have to really have the other side on board when you're making decisions like that. You can't just run off and make them unilaterally and, without thinking that there's going to be some kind of consequences.
Would that also be true for earrings? For example, if you let's say you want to get your daughter or your son's ears pierced, would you think that you would need both parents' consent, or is it really situationally
Well, I'm
decided?
kind of old-fashioned, so just earlobe piercing isn't going to bother me. Even if it's a boy, it's not going to bother me. But when you're talking about other types of body piercings,
Right. Okay.
when they're under 18, then you're starting to walk a very thin line.
Yeah, I would not recommend taking a minor and getting their body pierced, no matter how much they want it. This is just from a let's make sense here today. So that's great. Okay, if everybody, you're just tuning in, this is Grant Gisondo, the Family Man. Today we're meeting with and speaking with Magistrate Thomas Baker, one of the magistrates down there at the West Palm Beach Courthouse, talking all about time sharing as well as child support today. One of the other factors of the 20 that we're going to be looking at today, the homeschooling community record of the child. And every time I litigate this in court or I talk about this with someone, I have to talk about one of the very first cases that I had as I call it baby attorney when I first got started out. I had a case one time. It was right around this time of the year. It was probably late September, so a little bit further into the year. School was started for about 6 weeks. In 6 weeks, the child missed over 15 days of school already. I think that that's astronomical. I think that that's terrible. There was absolutely no health reasons. There were no health concerns. I questioned the parent that actually brought the child late or missed school for each one of these times, and the parent said, we just couldn't get there. And that was her official response in court, which is a huge, huge problem. If you have young children, folks, you need to be getting them to school on time and every day. Unless they're sick, they need to be going to school. This is really, really important. Again, not a super factor, but if you get to a time-sharing dispute or a custody dispute, as some of you still like to call it, we don't use those words anymore. We use time-sharing now. We're going to be looking at report cards and absences. Now, from a judicial perspective, I'm sure that you see report cards and school absences all the time. And when you see a child missing a ton of school or getting D's and F's in grades, that's got to be concerning for the court.
Sure, it weighs heavily, and you used a word a moment ago, on time. There's lots of situations where maybe the child isn't missing the whole day, but the 45 days out of the year, they're tardy, and it just shows, either a lack of interest in being a good parent or just bad parenting if you're not going to have the child attend school and have them prepared for school and have them fed for school. And these are the things that all fit into the puzzle.
Let's not also forget that you need to be getting your children prepared for school. And prepared for school isn't necessarily, only just dressed, fed, and to school. You as parents have a duty to make sure that homework is getting done. Make sure that summer reading is getting done. Making sure that your child is ready for a successful day in school. There's a lot more to being a parent, obviously, than just dress them, feed them, ship them off to school, check their homework. Make sure their homework is done. Believe it or not, some children won't tell you that their homework is done. You want to make sure that they are ready for the next day. Remember, you have to set these kids up for success in their life. You don't want to set them up for failure. And from a very young age, you need to make sure that your children are getting their schoolwork done. It's so, so important. You want them ready for the next day of school. The next factor that we're going to talk about today is the preference of the child. Believe it or not, when some judges and some magistrates will allow a child to testify if the court deems the child to be of sufficient intelligent understanding and experience to express a preference. Now, that gives the court a lot of discretion on whether or not the child is going to testify. Now, have I ever seen a 4-year-old testify in court? No. I truly hope I never do. I don't think a child that young needs to be anywhere near a courtroom. But what we're talking about here today is I think children maybe 14, 15, 16, 17, still considered, children, minors under the eyes of the court. Is there a rule on, okay, this child is of this age, they can now testify? I've always been of the opinion, no, there's not a hard, fast rule, but it's a case-by-case basis. Magistrate, have you had children testify? Are you looking for a specific age or any factors that you're looking at specifically in allowing a child to testify?
While this is just, again, one piece of the puzzle, it's a very interesting and could be a really big piece. The concept of having children testify is frowned upon by the courts, and that's why we have this rule that if a child is going to testify or even have their deposition taken, there has to be prior court approval for that. Sadly, there's a couple of misconceptions out there where parties think that they can just bring their kids to court and that we're going to just let them testify because they're the ones that are going to have their lives changed or not changed by the decision. And part two is that everybody thinks their kid is a genius and should be able to tell the judge or the magistrate what it is that they want. But the fact of the matter is that it's very traumatic for children to be brought into court. And I recently had a case where the child was over the age of 18 but had a sibling that was still part of the timesharing formula, for lack of a better expression. And so she came in to testify, but it was painful to watch. As an adult, she had the right to be called as a witness, but you could tell by her body language and the way that she conducted herself in court that this was just torture for her. And that actually weighed in my mind when I was trying to make my final decision as to what parent would want to do that to their child. So going back to the original point, we don't have a set formula, and you kind of recited the commentary from the rule that we try to look at and try to figure whether the child is of a sufficient age and whether they are sufficiently mature or even intelligent enough to come in and give, shed some light on what it is that's going on with the parents and the children and how material that information may be in helping us to make a decision. And probably, in my experience, elementary school children just are really not old enough or mature enough.
Sure.
Certainly, we all know some precocious grade school children, but
they're in grade school.
Yeah, and they're easily influenced.
Yeah, I think that even in their testimony would be somewhat unreliable in that they can be so easily influenced by parents. At that age, it's really just too young. And in fact, folks, if you'd like to read a little bit more about this, I wrote a blog recently on the website about a child as a witness, why children shouldn't testify, a personal opinion. And I listed a whole bunch of things. I interviewed some psychologists about what's going on in a child's mind at that age and how important it is for a child to have a loving, caring relationship from both parents, not necessarily a adversarial relationship in a courtroom. If you want to go ahead and read that blog, it's online at sunshinedivorce.com, Just click on blogs and you'll be able to find it. Something definitely worth reading. If you are just tuning in, this is Grant Gisondo, the family man, the owner of the law offices of Grant Gisondo, PA, a full-service family law firm located in Palm Beach Gardens, Florida. Call me today for a free in-person consultation regarding any family law case, 561-5 561-530-4568 or online at sunshinedivorce.com. My promise to you is that I will fight for you each and every step of the way. 561-530-4568. We're going to take a quick break and we will be right back.
Non-attorney spokesperson.
Without the proper training, diffusing a highly volatile bomb is not something you want to try by yourself. When a marriage is about to explode, the same wisdom applies. Hire a professional or pay the consequence.
Headed for divorce? Diffuse the matter with the guidance of the law offices of Grant Gisondo. Online at sunshindivoroce.com. That's sunshindivoroce.com. Main office in Palm Beach Gardens.
Welcome back, everybody. This is Grant Gisondo, the family man, the owner of the law offices of Grant Gisondo, PA, a full-service family law firm located in Palm Beach Gardens, Florida. Call us today for a free in-person consultation regarding any family law case. 561-530-4568 or online at sunshindivoroce.com. We will fight for you each and every step of the way. 561-530-4568. If you've been listening, we're talking with Magistrate Thomas Baker today, one of the magistrates at the West Palm Beach Courthouse, giving us an amazing insight from a judicial perspective today. Of course, if there's anything you would like us to cover, anybody you would like to hear from on this show, feel free to drop me an email, Grant, Grant, at sunshindivoroce.com or online at sunshindivoroce.com or call me at 561-530-4568. Talking about some of these factors today, we're talking about there's about 20 factors in this child timesharing and child support statute. We're going to hit some hot topics here, so I'm going to skip around a little bit. The next one we're going to talk about here would be the demonstrated capacity and disposition of each parent to provide a consistent routine for the child. Now, this is something that comes up all the time. Consistent routine, folks, I think this is going to go directly to co-parenting. For example, if Monday the child is with mom in the event of a divorce or with mom in the event of a custody case, and the child is going to bed at 8 o'clock, and then come Tuesday, child is with dad, and the child is going to bed at 10 o'clock, that's a problem. That's where co-parenting comes in. You have to be somewhat consistent in your routines, but also in mom's household, we're looking for consistency there. In dad's household, we're looking for consistency there. Magistrate Baker, anything that you're seeing come up in this, any pet peeves coming up in this regarding this factor?
Well, you kind of mentioned earlier just the fact that, to be a good parent, whether you're having problems with your ex-spouse or the other parent of your child, is to, be consistent and help them both prepare in the morning for school, but prepare at night for having homework done and things like that. The statute actually even mentions homework, meals, bedtime, which for those of you that ever want to get sleepy and read the statutes, it's unusual for them to try to be so specific about a particular topic. So one of the things that we see is what you described, where really the little kid should be going to bed consistently at 8 o'clock or 8:30 every night, but when they're with mom or dad who's not doing that and lets them stay up and play on the computer or play video games until all hours of the night, it comes out eventually if their teacher is called as a witness, and the teacher will say, I know when little Jimmy is overstaying with dad because he's tired, he can't stay awake, he's not prepared. It's painfully obvious to the teacher, and that's going to be a really important factor that we're going to look at as far as what's in the best interest of the child, whether that child should be spending school nights with that particular parent.
See, that brings up a question to me. So how important do you think it is that when the child is at mom's house versus the child at dad's house, that they kind of get together and they come up with a consistent routine? For example, home from school, playtime, dinner, homework, and bedtime. Should that be mimicked in both households?
Absolutely. But I'm not living in a Disney environment. I realize that lots of times these adults, for whatever reason, couldn't stay together, couldn't keep their relationship together. And I know it sounds corny, but it really all goes back to communication. So they might have had a bad time communicating even when times were good, and now that they are living separate lives, communication can be very difficult. We do have certain tools that we try to help them with by using internet programs such as Talking Parents or OurFamilyWizard.com to try to help them reach out to each other and communicate about whether it's medical issues or academic issues. But still, it's really up to them to kind of put aside their personal differences and do what's in the best for the kids.
Yeah, and then that's actually a great module that he brought up, Talking Parents, Our Family Wizard. For those of you that are unfamiliar with those are actually computer programs that are internet-based that you can log on and you can send the other parent a message, and then the other parent is notified. They can log on and respond to the message. But even if they don't respond to the message, you can see that they viewed your message. Everything is time-stamped. So in the event that this actually gets into a courtroom, you can print out all that correspondence and actually use it as evidence going back and forth to show conversations and to prove your case if needed. Again, I completely agree. Communication is absolutely everything when it comes to marriage, parenting. Basically, it's probably one of the most important things you can have in a relationship is communication. We've come a long way since the days of telephones. Now everybody is texting and emailing and Facebook messages, but those two modules are actually really good, and I'm happy you brought them up. If you have questions about Family Wizard or Our Family Wizard or Talking Parents, feel free to give me a call or shoot me an email, 561-530-4568. You can email me at Grant, Grant, at sunshinedivorce.com. The next factor that I want to talk about just a little bit is kind of in the middle of this statute, the demonstrated capacity of each parent to communicate with and keep the other parent informed of issues, activities regarding the minor child, and the willingness of each parent to adopt a unified front on major issues when dealing with a child. Now, this is something, this goes right into our communications that we were talking about, but one of the things that I see all the time is that, a parent will come into my office and want to reduce the amount of time sharing with the other parent, and we'll talk about this factor, and they'll actually tell me, well, that person, the dad or the mom doesn't show up at doctor's appointment, doesn't show up at parent-teacher conferences, doesn't show up at extracurricular activities, doesn't show up at sport games. And then when I take the other person's deposition, they say, well, I didn't know those things were happening. I didn't know there was a doctor's appointment. She made the appointment or he made the appointment. They never told me. I would love to be there. So one of the things that we want people to stay, in touch with is that if your child has a doctor appointment, you have to communicate that to the other parent. If there's a parent-teacher conference, you have to communicate that to the other parent. Then if they know about it and they still don't go, it can be used against them. This has to be something, Magistrate, that you see all the time in the courtroom about parents not showing up for things or not showing up for things because they don't know about them.
Yeah, unfortunately, it seems that one parent, either willingly or unwillingly, ends up having to burden most of the time involved in taking the kids to the dentist or doctor appointment or meeting with the teacher or other school administrators. But as you mentioned, sometimes the other parent wasn't aware of that, and I unwittingly kind of stepped into this particular factor when we were discussing the other factor because this is not a commercial for Talking Parents or Our Family Wizard or any other kind of communication device that's on the internet. But these things do help document and keep everybody on their best behavior, since it is something that can be printed out and presented in court as evidence as to someone's either lack of wanting to be involved, or if they are going to be negative to the other parent, then we'll see that in black and white.
Right, and I'm sure that, in deciding on some of these cases in the event of a trial or a contested hearing, you would much rather see a printout from Family Wizard or Talking Parents than a whole bunch of text messages. Am I kind of right, or do you not care?
Well, it's tough when somebody shows up and they've got a binder full of whether it's emails, texts, or maybe the printout from Talking Parents, for example, because just from a time perspective, it's difficult for the court to read everything.
Right.
If they're handed 50 or 100 pages of emails or texts.
Right.
The bad thing about texting is that typically there's not something that indicates what date the text was. I mean, sometimes there is, but even then you don't know what year it might have come from. So with emails, at least, you can actually tell when something was sent.
And folks, this comes down to, again, why you need to be hiring an experienced family law attorney to represent you in these actions. You don't want to show up there with 1,000 pages of text messages or emails that go through 5 years of history. You really need to sit with an experienced family law attorney, go through those, let him or her go through those, or give me a call. I'll go through them with you and find out what's really important. What do you really need to show this for? Why are you putting this on as evidence? And what do you need to show? Do you really need to show 1,000 pages, or will 4 pages get your point across? Remember that these magistrates and judges, they have an overwhelming amount of cases coming at them, and I'm sure they'd much prefer to read 4 pages of evidence than 1,000 pages of evidence. You want to kind of get to the point, and you want to move on to the next factor, because as Magistrate Baker was saying that, there's 20 factors. If you're going to put 1,000 pages on one factor, you probably just chewed up 2 or 3 hours talking about one thing when you have another 19 factors that you need to get through. So again, as far as economy goes, you want to make sure that you're putting on evidence that's relevant, important, and you can move on. So that's a great tidbit. Thank you very much. If you're just tuning in, this is Grant Gisondo, the family man, the owner of the law offices of Grant Gisondo, PA, a full-service family law firm located in Palm Beach Gardens, Florida. Feel free to call me today feel free to call us today for any free in-person consultation regarding a family law matter, 561-530-4568. We're here with Magistrate Baker today talking about some of the different factors that go into a child custody case. Now, although there are 20 factors, I want to talk about one more factor, and then I briefly want to talk about child support. So this last factor that we're going to talk about today is the demonstrated capacity and disposition of each parent to maintain an environment for the child which is free from substance abuse. This is a huge topic. It seems like 50% of the people that come in my office for that free in-person consultation say, my spouse is an alcoholic. And I say, well, why do you say that? And they say, well, they have 3 or 4 drinks every single night, and that means they're an alcoholic, and that means that this factor's on point, and they should never see their child. And I tell them, I'm sorry, you're wrong. That's really not what we're talking about here. Sure, if you go home and you drink 10 beers and you're a flat-out drunk every single night, yes. If you're doing illegal drugs, or you're smoking marijuana, or you're doing all these things, yes, we're talking about this factor. But just because you have a drink or two doesn't mean that your house is filled with substance abuse. Again, not a super factor, but definitely something that's commonly misunderstood that we're talking about today. So, Magistrate Baker, house free from substance abuse, what are you looking for in that type of situation? What would you consider substance abuse?
Well, sadly, whether someone actually is an addict with some type of illicit drug, or if they do just have alcohol problems, it's sad for them, but just made extra sad if children are involved and witness to these types of things. Unfortunately, someone will come in. The typical scenario, somebody comes in and says, yes, they're an alcoholic, or yes, they smoke pot. But it's like the pot calling the kettle black most of the time, because these people at some point had a relationship. So all that does is the other person turns around and goes, yeah, well, he or she used to do it too, and still does. So it turns into a real he said, she said problem normally. But certainly I have to sift through the credibility of the witnesses and try to determine, again, what's in the best interest of the child. So, if somebody, again, going back to the Facebook post, for example, if somebody's sporting cannabis leaf paraphernalia or T-shirts and hats and tattoos, then that's going to be a little tough to overcome, when I'm looking at this particular factor.
Sure. And again, it brings me up of another story of one of the first family law trials that I did. I had a father show up to court wearing a black T-shirt with a gigantic marijuana leaf on the front. I said, are you kidding? Go downstairs, go out the street, find a T-shirt, find a polo shirt, find anything you can, but rip that shirt up and do not bring it into the courtroom. Not a great idea, but this is the real world stuff that we actually deal with. There's a million comical stories that I could tell you. If you have a story that's funny and you'd like to talk about it, or you'd like to discuss it with us on the radio one day, give us a call, 561-530-4568. I'd love to hear it. Of course, if you have questions, give me a call, 561-530-4568. Or if there's a topic you would like us to cover, or you have questions about anything we've covered today, you can email me, grant@sunshine.org. sunshinedivorce.com, or call me 561-530-4568. We got just a few minutes left, so I want to briefly talk about child support. Child support is one of the exclusive things that magistrates are going to hear if that's the only issue in your case in Palm Beach County. Again, joined with Magistrate Thomas Baker today. Now, child support, everybody finds this to be incredibly confusing. When you look at child support, it's somewhat simple. You're looking at the incomes of both parties. You're looking at the amount of overnights the child is spending with each party. And again, remember, folks, 2 shows ago, we spoke all about child support. We only care about overnights, where days are not really a factor in this situation for today's purposes. And then we're looking at the expenses of the child, expense like daycare, expense like insurance, or if there's any special needs of the child that need to be met, that's included. Would you agree, Magistrate, that it's a relatively simple calculation that's done by computer programs, or are you thinking that it needs to be as complicated as people make it out to be?
No, you kind of stole my thunder. It's really not that complicated. What we're looking at is the net incomes of both parties, and then these other expense factors that you mentioned, such as daycare or non-covered, health insurance premiums, things like that. It can get trickier when someone is self-employed, and that usually presents a problem for one side trying to prove the income of the other party, because someone that's self-employed may or may not even be filing their income taxes. And that's not something that we're going to pursue. We're not going to report somebody to the IRS just because they even admit in court that they don't file their income taxes. Right. But it presents an evidentiary problem as to how much they actually make. There are other ways that a skilled attorney can imply what somebody's income may be, and then there's expert witnesses that can be brought in to do that. So it sometimes can get a little more complicated, but it really shouldn't be that complicated if especially when one person knows what the other person made, where the secrets may be or where the stash may be, then they should be able to prove what the other person makes.
Sure. I mean, in my experience, most of the time we fight about incomes. This is what the person's making, and then overtime and things like that. But if you're a W-2 employee, things get really simple. It's when you're self-employed, and the vast majority of the people are W-2 employees. They get a paycheck every single week, and that's how they're paid. The rest of the factors on the amount of overnights is where there's a lot of litigation and stuff like that. So, again, thank you very much, Magistrate Baker, for being with us today. These judicial insights have been invaluable. I greatly appreciate you coming on the show today. I hope you had a good time.
Absolutely. I appreciate you inviting me, and hopefully I can come back again sometime.
Definitely. We would love to have you back. If you have any questions about the show today, or you have any questions that you'd like to ask of me, feel free to shoot me an email, grant@sunshinedivorce.com. Again, this is Grant Gisondo, the family man. I'm the owner of the law offices of Grant Gisondo, PA. We are a full-service family law firm located in Palm Beach Gardens. Call us today for a free in-person consultation regarding any family law case. 561-530-4568, or online at sunshinedivorce.com. We will fight for you each and every step of the way. 561-530-4568, and online sunshinedivorce.com, because nobody can spell GisondoLaw.com. Hope everyone has a wonderful week. We will see you next week with another exciting family law topic. Have a great day. Be safe and be kind to one another.
Non-attorney spokesperson.
Without the proper training, diffusing a highly volatile bomb is not something you want to try by yourself. When a marriage is about to explode, the same wisdom applies. Hire a professional, or pay the consequence.
Headed for divorce? Diffuse the matter with the guidance of the law offices of Grant Gisondo. Online at sunshinedivorce.com. That's sunshinedivorce.com. Main office in Palm Beach Gardens.